Robert C. Gottlieb is a former Manhattan prosecutor and founder of criminal defense firm Robert C. Gottlieb Associates PLLC. Opinion. CNN has more views. Former President Donald Trump made history in more ways than one. The be impeached twice. The first president to incite insurrection against America. And the be indicted by state and federal prosecutors 4 times. He may now become the first president to televise his criminal trial. Courtesy of Robert C. Gottlieb. Robert C. Gottlieb. The disturbing spectacle of Trump daring federal district judge Louis Kaplan remove him from courtroom for disruptive behavior during the second day of Jean Carroll's defamation trial on Wednesday underscores need for people to be allowed judge what happened. Trump case during Tanya Chutkan, federal judge overseeing the election overturn case against Trump, is considering an application by a media coalition to televise what has been accurately described as most important trial in American history. The media relies heavily on public's First Amendment right to participate in criminal trials. This is an interpretation of the First Amendment rejected by prosecutor special counsel Jack Smith. His opposition is based primarily on Federal Rules of Criminal Procedure Rule 53's ban on courtroom photography and broadcasting of federal hearings. Whether Rule 53's ban on the publication of all federal transcripts violates the First Amendment is an issue that has given rise to arguments both for and against among constitutional scholars. But Judge Chutkan need not decide which argument prevails. There is an expedited solution that would allow the hearing to be televised. The Supreme Court has the authority to amend Rule 53 to allow for gavel-to-gavel televised coverage of the Trump trial. Let's talk about unconstitutional objections frequently voiced by cameras on opposite side of courtroom. Cameras in the courtroom negatively affect trial witnesses. I have first-hand knowledge of this stress, having testified in many cases. But this concern is flawed. Testifying in court is always an uncomfortable situation, whether the cameras are looking at you or not. At every high-profile hearing, whether televised or not, the media is omnipresent and there are reporters sitting in the front rows writing. Witnesses cannot avoid knowing that the media is watching, hanging on every word, whether or not the hearing is televised. Witnesses are often tapped and recorded for broadcast outside the courthouse when they come to testify. There is no empirical data to support claim that addition of a small, fixed, silent camera in courtroom increases stress of witnesses beyond stress they already suffer knowing that reporters are in courtroom and covering their testimony. Broadcasting the hearings on television will lead to lawyers and even judges taking to the stands. In fact, in a 4-year pilot program conducted by the Federal Judicial Center on video recordings of courtroom hearings in 14 Federal